First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. Welcome to the First District Court of Appeal. The first case we have this morning is number 2018-43, Joshua Koop versus Miami Shores Village. Mr. Bichelle, are you ready?
Yes, sir.
You may proceed.
May it please the court, I'm Robert Bouchel. I represent the appellant Joshua Koop. I'd like to reserve 3 minutes for rebuttal. If the Veterans Preference Statute is meant to provide a preference and priority in the promotional practices in this state, then the preference is more than a symbolic thank you for your service. Joshua Koop did not ask to jump the line for promotion. He was entitled to the veteran's preference that would firmly keep his place in line, the next to be promoted to Sergeant of Police. This appeal cannot be characterized as arguing against the factual findings of the hearing officer or PERC. Rather, the appeal attacks the legal error made by the hearing officer and affirmed by PERC.
Well, Mr. Bichelle, here's my question. The CBA says that the chief of police shall be the final authority in determining which officers are to be promoted and the sequence of their promotion. So as I see it, there's a test and a board, and based on the test and the board, they rank order all these people, but the chief is not required to start at number one and go down in order. You know, if there are 4 sergeant vacancies, he doesn't have to pick the first 4. He can pick the last 4. So it's not really a numerically based system.
That's what you just did, Judge, and what the hearing officer did. It is not a numerically based system, but first, when the veteran's preference must be applied, the court must look to .09. And to read that, it says, when an examination for promotion is utilized, such person shall be awarded preference points. It doesn't say the whole system has to be a numerically based process. And it is replete throughout the hearing officer's recommended order is promotion process, starting with paragraph 6 of her order.
So let me see if I understand your argument. Your argument is that despite what it says about the chief of police having the authority to pick anybody on the list, but when the list is compiled, the veteran should receive his points at that time, and your client would have been higher on that list if he would have been properly awarded those points, and that might have affected his ability to get the promotion.
Both, and not only higher on the list, he's next on the list. And before he got the veteran's preference, he was next on the list for the second round of sergeant. So he would have gone from 3rd to 2nd if you added the 10 points that's required under .08. What the hearing officer and PERC did was jump out of the statute. You must start with the statute if a veteran's preference is in play. And indeed, the testing center asked that very question of the chief. They said, do you want us to add veterans preference points? Chief said no. Do you want us to add seniority points? No. Okay, well, these should have triggered the chief to say, why are they asking about veterans preference? What we have here is a recognition that Koop was not given the veterans preference, and he deserved it. And the chief admits it, and he went about it the wrong way. So now we have a system that's supposed to recognize the veteran's preference and shall appear in an equal or lesser permission on the promotional register. What was created by the 3-day test, oral exams that were videotaped, and written tests that had to be studied for 6 weeks. What was produced was a promotional register. And as of this point, Joshua Koop is number 1. And when an examination is used, a numerical response is yielded from a numerical score. PERC agreed that Koop was entitled to the preference, and the statute commands that 10 points be added. Now he becomes number 1. The statute says that that promotion has to happen, and any discretion that exists for the chief, it applies to non-veterans. The statute does not say look elsewhere to determine if the promotional process is numeric. The hearing officer stopped reading the statute and went to the CBA first, finding factors the chief could rely upon The hearing officer referenced paragraph 33 and 34, a previous promotion process, numerically based selection process. This is all not contemplated by the Veterans Preference Statute. It considers a numeric.
I'd like to discuss another provision of the statute which deals with how many promotion preferences a veteran is entitled to. And there were some findings of fact, and obviously this is an alternative basis for potentially affirming the order of PERC. And so why isn't the statute that says the only promotion preference to be given is the first promotion after the veteran returns to employment? And there certainly was a change in position from police officer to detective. With that position change, there was a salary increase, there was a title change, there were additional responsibilities, there was a probationary period, there was a ceremony marking the change in position. And so my question is, what are we to look for when we're construing the words in the statute promotion? What do we look to?
First of all, we look to see if there's a finding of fact below. And I don't think the court can necessarily substitute its finding of fact that this was indeed a promotion to detective versus a transfer. But I will say,
isn't that a legal conclusion? I mean, the facts are undisputed about what happened, but in terms of applying the law to those facts, isn't that a pure legal?
I would say a ruling. There is not one police department in this entire state that considers or can consider that a detective is a promotion. It would rock the foundation of every collective bargaining agreement. Neither party considers it a promotion. That is just a misnomer that was in the chief's policies and procedures. It is considered an appointment. It is not considered a promotion. You supervise no one. And it is outside the chain of command. A detective does not supervise police officers. Sergeants are supervisory. So PERC did not rely on that. The village of Miami Shores did not rely on it.
Well, in fact, the village did. And I mean, the applicant can certainly answer this later in the argument. But in the record, there certainly is an assertion by the department that it was a promotion. They attached all kinds of exhibits that were admitted before the hearing officer. So they certainly took the position that the change in rank to detective was indeed a promotion within the meaning of the statute.
Only for Joshua Koop do they take that position. When the chief recognized that he made a mistake, first, you'd have to believe the chief didn't know that the veteran's preference existed. And then after the fact, he went, oh, well, if it does exist, we applied it to detective, and we're going to say that's a promotion. There is not one police department in the state that can consider it a promotion. It is not contemplated by the collective bargaining agreement. It is referred to as a transfer. It is referred to as an appointment. It is complete discretion by the chief to appoint any police officer to the position of detective. And lastly, it is.
So how does one become a detective?
I'm sorry?
How does one become a detective? There are a certain number of vacancies and people put in an application. Do they go before a board? Do they get a raise? How does it work?
The police, it varies from police department to police department.
So it's kind of a factual issue because I get some places it seems like it would be a promotion, some places not. I know, like for instance, in the Leon County Sheriff's Office, if you go from patrol to detective and then you want to go back to patrol, you just go back to patrol. You're still a deputy sheriff. It's all deputy sheriff. But other places, more money. It's more prestige.
It describes job function. Detective is a job function. It's investigatory. They don't answer 911 calls like a patrolman. Although you could be put in a particular unit that's plain clothes and be called.
Well, is it competitive? Is there a board? Is there a test?
There's like I said, it varies from department to department. But I think it varies from department to department. A sheriff can just say, I'm making you a detective today.
Okay, well, how does that work in Miami Shores Village? How did Mr. Koop become a detective? What was the process?
There is contemplated from the collective bargaining agreement an exam that is taken, and then the chief gets to decide completely from that who he wants to be a detective. And by the way, this also, lastly, this was not presented by the village as a ground for affirmance. They did not argue this in their brief as well. But I am.
Well, the council, it matters because the statute says that it matters. Whether it's been raised or not, you're asking that we apply a particular statute that says that it may not apply in certain circumstances, and it may not apply in your circumstance. So whether the village brought it up or not, it matters.
It is for the reasons stated, not a promotion because it is not supervisory. It's not contemplated as a promotion. And he didn't ask for it, by the way, for the veteran's preference. And that's also a key point here. You have to ask for the veteran's preference for the promotion.
What's your basis for that? Like because that's not expressly what the statute says. So how are you coming to that conclusion?
That is the first, okay, I'm sorry, I misspoke. It's for the first time you ask for a promotion. So but the detective position is not a promotion. Like Judge Roberts says, you could be put back in patrol in an instant, and that is anywhere in the state of Florida. And so I respectfully think we're getting bogged down with whether that was a promotion when even the village finally recognized, and the hearing officer and PERC recognizes there's not a place in the state of Florida where a detective is considered a promotion.
Well, except the problem here is that the statute is 295.09 is not specific to police departments. It's generally dealing with employment. And in other employment contexts, I think most people would consider getting a raise, having a big to-do about getting the new position, having to apply for the position, getting a new, insignia for it or something like that. All those trappings of the position would strike a lot of people as a promotion. Why is it that specifically to police departments, and your claim that no police department in the state of Florida would consider going from street patrol to detective as a promotion?
Because there's no remedy under any collective bargaining agreement to object to your reassignment from the detective division. But you do have those rights when you're a supervisor, when you're a sergeant. So if you were demoted, improperly demoted, then you could object under the collective bargaining agreement and file a grievance, and it could be arbitrated. That cannot happen. Completely management rights for the particular assignment, which is a detective. It is an assignment, and some assignments you could be sent to the canine unit and get paid more. That is in road patrol, and that is you get paid a little bit more. You could be assigned to a special tactical unit, the traffic unit. Every unit, specialized unit, even those that are in same uniform, sometimes have incentive paid. If you're on the midnight shift, you get a midnight shift. It's the same job, just a different time of day. It's not a promotion. You cannot.
Are you suggesting that detective pays more because they have a shortage of people interested in being detective, and so this is an incentive to get people to want to do it?
I can't honestly represent that. Sometimes yes, perhaps no. It's a preference. Some guys like road patrol. Some guys don't like doing investigative work. It is a different function, a different job function.
Mr. Koop, your client did apply for detective, right?
And he is a detective, and he's
right.
A detective in good standing. And so when you have what's interesting is when what PERC outside of the hearing officer, you try to compare the candidate that was promoted and Joshua Koop. They threw in another factor. Hey, not only that, the last guy scored #1 on the detective exam. And that's not a factor anywhere. And that's how random and unfair this particular process is because it's like saying you win the algebra award because you scored #1 on the history exam. It's not noticed, it was not explained, but yet PERC made its own discretion in that circumstance. The chief is not entitled to his own discretion. He admitted he went about it the wrong way. That is a quote. He did not know about it. The chief was asked about the veteran's preference, and he denied the scoring offered by Miami-Dade Testing Center. He admitted that he wrote notes after the fact, justifying why he did not apply the veterans preference, or misleading that he did apply it to the Department of Veterans Affairs. The chief was unaware of the veterans preference, but after the fact makes the argument that he applied it to Koop.
You're well into your rebuttal time, Mr. Bichelle.
Oh, I'm sorry.
You have 28 seconds, 27 seconds. I'm gonna give you 2 additional minutes because we contributed to you burning up your rebuttal time, so you'll have a rebuttal time. And of course, Mr. Carson gets another couple of minutes if he chooses to use it.
Very well. Thank you.
Mr. Carson?
Yes, thank you. May it please the court, I'm Leonard Carson from the law firm of Carson and Atkins. I'm appearing on behalf of the Appalachian Miami Shores Village. Let me first turn attention to the promotion of detective. The bargaining unit certification by PERC shows the ranks in that department are police officer, detective, and sergeant. There was an application process. Mr. Koop applied for it. He was tested, he was interviewed, and there were there was recommendations made by other supervisors as to whether he should get that appointment. He got a pay raise. He obtained an increase in status. Our feeling was the evidence showed, and the hearing officer found all the facts in favor of being a detective, being a promotion, but the legal conclusion was different. And I believe that this court has the ability to correct that legal conclusion if you so desire. But let's talk about what the issues are here. There are 2 fundamental issues in this case. One is whether the system for selection of a promotion is numerical or non-numerical. And the other is, if it's non-numerical, did the chief choose the most qualified individual for the job? The veterans preference statute in the numerical system is based solely on a score of a test. That score is augmented by a specific number of veterans preference points to determine a final score, which determines the ranking sequence of the candidate on a promotional register. The augmented score is the sole measure of the candidate's position on the register, and candidates are selected from the register in rank order. The selection process is numerical only when it relies solely on the numerical score as the only criterion for who will be selected in the order of selection. In this case, the employer selection process.
Counsel, on that, can you point to me or point to us the part of the statute that says that it has to be solely numerically based?
There's nothing in the statute that says that, but it's apparent when you show 2 systems, one numerical and one numerical. There's no language that addresses the hybrid system, which was used by the village, where they used it both in the exam and other factors. But let's talk about the point system, because Mr. Bushell suggests that you simply add 10 points to it. That's not the case.
Well, hold on. Before you move on to that, let me your point that there's no reference to a hybrid system, but isn't there actually a 295.085 suggests that there's not a hybrid system? Either there is a written examination of some sort, or there's not. And if there's not, then 295.085 would apply. And if there is a written examination, then 08 and 09 in fact would apply.
If you made the dichotomy simply between a written examination or not, there would be nothing to consider when you have a hybrid system. There's nothing.
Sure there would be, because you could still add preference points to the score of the written examination.
Well, let me address the preference points, because I think Mr. Bichel's point in that regard is incorrect. First of all, Mr. Koop had the burden to establish that the promotion system is numerical, that he's entitled to augmentation points and the proper number of those points. So if we assume that it was a numerical system, he's not entitled to simply augment his score by 10 points, which is what he's suggesting you do. In Rule 7.0105, it establishes a promotional-based system for augmenting points based on a maximum test score of 100. If the total possible score is less than or more than 100, percentages must be calculated to decide how much of that 10 points is to be added or augmented. Now, the system used Miami-Dade College doesn't lend itself to augmentation because there's no way to determine from the record evidence the maximum score that was possible on the written examination. So unless you know that, you don't know how to apply or augment the points. Mr. Koop was responsible for providing evidence of that. He did not. And so he's failed to prove how many points or any amount of points that he was entitled to be augmented, because you simply can't look at the record and determine how many points he would be entitled to. But we categorically say it was a non-numerical system because if you treat what happened in Miami Shores as a numerical system only, you ignore all the other factors that the parties have negotiated for in a collective bargaining agreement to be the basis upon which they select a sergeant.
Sure, but the statute is clear that the collective bargaining agreement cannot override the preference system put in place by the statute.
That's correct, but there is no conflict between the collective bargaining agreement and the veterans preference statute in this case. What happened
Well,
was
just that if there's a collective bargaining agreement that interferes with the operation of the statute, then you can just ignore the requirement that there's a preference augmentation if there's a written examination.
Your Honor, it's clear from the language of the collective bargaining agreement that it was not the intent of the parties to rely on the exam and interview scores as the sole determinant as to who would be selected and as the order of selection. Those scores are only a small part of the negotiated selection process. And because the village uses much other criteria, it's not a numerical process within the meaning of the statute, and the parties didn't intend for it to be. So there's no conflict. And what happens when you have a non-numerical system is the chief does not get away home free. He's obliged by the case law to prove that the candidate he selected was the most qualified or the better qualified candidate. If he fails to do that, he's reversed. And he was able to do that. That's a factual determination to be made by the hearing officer. And she found all the facts in favor of Mr. Zalonis being a more qualified candidate.
Sure, but do you agree though that there was a written examination? Right? I mean,
Yes, I do.
That seems undisputed. Okay,
Yes,
there's a
sir.
written examination, and Detective Koop is a veteran and would otherwise qualify under the statute for a preference if he met all the other criteria. So what is the basis for the village to just categorically dismiss the operation of this preference system?
We didn't. The augmentation points only apply if it's a numerical system.
But you're basing that on you're basing that on what the department says, right? Not what the statute says.
I'm basing it upon a fair reading of the statute and paramateria. You have a numerical and a non-numerical system. And what the hearing officer had to determine was what system did the Miami Shores selection process fit under. The only one that was plausible was non-numerical because you're held accountable to select the most qualified candidate. Points, the exam score was considered as part of that selection process, but not the entire determinant.
But there was a score for the written exam, right?
Only for the written exam.
Right. So there was a number that could have been augmented under the statute.
You can't follow the rule and augment the score because you don't know what the maximum score was. There was a
right,
number.
But the statute does not talk about prorating or anything like that. It just says that here are some points that you need to assign under certain criteria if there's a written examination, which there was here.
The augmentation proportional rating system is in the rule, not in the statute.
Okay. Can the department override the meaning of the statute by rule?
I don't think we did do that. We were trying to follow the statute, and Mr. Bushell said the chief didn't know it existed. The problem was the statute speaks in terms of special consideration without definition. The only special consideration it's spoken to in the rules, which the department is obliged to promulgate, is give an interview. There's no way to know how to apply special consideration. So what the chief did was he considered all of the factors that the parties had negotiated in their agreement. This is the way in which we were going to select the sergeant. He utilized that system, and then he stood the test of whether he had done so properly. The hearing officer, it's a finding of fact determination for the hearing officer. She found the facts supported his conclusion. So we are consistent with the statute. We followed the veterans preference statute by properly employing a non-numerical system. And the evidence supports that he selected, and if your case law does, particularly from this court, that when you select the most qualified individual, then any other procedural errors are moot. We gave preferences to the extent was necessary. There was no step at the process at which Mr. Koop was not being considered. Did I answer your questions, Judge Tannenbaum?
Mostly,
Okay.
but I don't want to occupy the entire time, so I will yield.
Well, first of all, the
Carson, I have some questions.
Yes.
What makes a numerically based component numerically based? So just some hypotheticals. What if the grade that you asked for the college to provide was a letter grade or a qualified or not qualified status? Is the fact that there is any counting involved at any time, does that make a process numerically based? Or if the candidates were ranked A, B, C, and D, or qualified, not qualified, what makes a system numerically based or a component numerically based?
What makes it numerically based is if it is the sole measure of the candidate's position on a register. Now, if you look at the collective bargaining agreement, the chief could ignore the register completely if he found no satisfactory candidates within the department. There were other factors we can't ignore, that there were the broad range of criteria that he was able to select from, which makes
I
it
understand that. And
non-numerically.
I just, let me interrupt you because I know we've talked about the sole factor, but let's assume for a moment that the fact that there is a numerically based component anywhere in the process, kind of infects or transforms the entire process and makes it numerically based. What makes a particular component numerically based? Let's say, again, that you use letter grades or qualified versus not qualified rather than ranking the opponents by number. Would that be a numerically based system?
No, I don't think so. I think you must have a number and it must be the sole determinant. Nothing else applies. We're not saying that the non-numerical system doesn't have as part of it a numerical quote sum. There was a test given, there was a score given. We don't know what that means in terms of the maximum score, but it was one of many factors. So you have two choices.
And let me interrupt you again. I'm sorry. So another factor that the police department considered were the number of commendations, the number of disciplinary actions against the officers. Do those components make it numerically based?
No, they do not.
Those are numbers, are they not?
Well, I think what you're demonstrating, Judge Rowe, is that if you carry this, what the statute, first of all, the statute is less than artfully drafted. There's a lot, it could have been drafted much better. And what you're saying is any reference to a number, and this is Mr. Bouchel's contention, any number makes it numerical. We don't subscribe to that because to accept that proposition ignores any other factors. The chief testified at the hearing why he had gone and why the parties had agreed in collective bargaining to go to a non-numerical system, because they found the numerical system alone was unsatisfactory.
And actually, let me ask another question. So for many positions, you have to have a required number of years of service. So for detective, you had to have at least 1 year of service as a police officer. Certainly the years of service is a threshold consideration for even qualification for the position. Again, we're looking at numbers there as well. So, what is it that makes the numerically based component special and where we should be adding the points for the veteran?
When the number is the sole determinant and it determines the rank from which the persons will be selected. When it tells you number one is the guy you appoint or select, then it's numerical. This is not the system. It was one of many factors. Numbers were one of many factors that were used by the chief to find a comprehensive determination as to who was best qualified. And I think if you carry it to its extreme, you would be ignoring all other factors and limiting the opportunity to select the best qualified candidate.
Okay, counsel, let me ask you this. Let's take your paradigm, this numerically based, non-numerically based paradigm.
Yes, sir.
How is it? Doesn't 295.085 then apply?
It's hard to understand standing alone what 085 really means, because it doesn't talk in terms of what does it mean to give a first or second preference. It categorizes it, but it doesn't answer the full question. I think this is an example where the statute is less than artfully drafted. I think if you have to look at the case law against the statute, and you have two systems, basically numerical versus non-numerical. Numerical means sole determinant, tells you what the rank order is, and that's the method by which you select your candidate.
Sure. Well, what effort did the chief in this instance make to abide by the statute in some way or another?
I'm sorry.
Maybe it may not have been precise, but in what way did the chief make an effort to give I guess probably be a second preference here?
Mr. Koop was considered at every step of the process until the final determination was made. In a
I
normal
mean,
system,
he was given some sort of preference because of his service?
well, that's the question. The department was supposed to draft rules telling us what a special preference is, and there's nowhere in the rules that you can determine that except for an interview.
Which and what law do you rely on for the authority to just ignore a statute if there's not a rule in place?
We're not ignoring a statute. We're following the case law that interprets the statute and says when you have a non-numerical system, the obligation is to select the most qualified individual. The statute speaks in various places, particularly in the promotional article in 09, that you get the preference only if you are equal to or better than, it's a tiebreaker. But if someone is better qualified, there's no guarantee of that a promotion. It's not an automatic promotion because you're a veteran. It puts you in line for competition.
Would you agree or disagree, though, under the statutes or this mosaic of statutes, that there's some intent that a veteran who fits the definition is supposed to get some sort of acknowledgement, preference, something to put into the mix when considering him or her for a promotion?
Certainly, Your Honor. In a numerical system, the number alone tells you what the ranking is and what the sequence will be of promotion. In a non-numerical system, the preference we give is we are obliged to select. We can only select someone other than the veteran eligible person if the individual we select is more qualified. That's the criterion, and we have to, the hurdle we have to meet. And it's actually a heavier burden than just looking at the numbers. We have to, and if the chief would not be able to support his conclusion based upon all of the criteria he selected, that this individual is more qualified, the veteran would have gotten his preference.
Right, but didn't the chief acknowledge essentially that he didn't consider veteran status at all?
No, I don't think that's a correct reading of the record. He didn't understand how adequately to apply it. He was confused as to how to apply it. He took into consideration military service, but didn't really know how do you go about applying the special preference. It's not clear, wasn't clear to him. But when Koop applied for the detective position, he did not indicate he was looking for veterans preference, nor did he do it in a promotion until after the promotions were determined. And so what the chief did was he went back and knowing that there was a preference, is there anything else that would change his mind as to who was the best qualified individual for the position? And he concluded no. The collective bargaining agreement expresses the intent of the parties.
Mr. Carson?
Yes.
You're over your time.
Well, thank you, Your Honor.
I appreciate your argument. Mr. Michelle, you are recognized for rebuttal. You're on mute.
Thank
There
you.
you go.
Thank you for reminding me, and thank you for the time. Paragraph 75, Koop of the hearing officer's recommended order states, Koop was not afforded preference during the sergeant promotional process. If this case doesn't illustrate departure from the legislative intent of veterans preference, then no case does. It would require the statute to be subordinated by the will of the chief who was savvy enough to convince a hearing officer that his discretion overrides the objective and rigorous standardized testing. And so when we get to the point where every time that my brother counsel for the village says, well, the chief considered this and the chief considered that, we get into Judge Rowe's question, which is how do we take the quantified rigorous testing that yields a number, and then we have the chief who says, well, I like this type of discipline, or how do I balance it against, how do we measure the numeric process versus a non-numeric standard? And that's where the problem is in this case. The chief tells you in his own words what he did. This is his standard. He explained the process is looking at every.
Mr. Michelle, can you hear us?
bad internet connection.
Okay.
I
Mr.
hear you,
Michelle
George.
appears to be locked up. We will stand by and see if his connection clears. And if it does not, we got the gist of his argument and a good bit of his rebuttal. So who can hear me?
I can
I
hear
can
you.
hear
good.
you.
Okay.
You might try to call back in.
Yeah, he
Maybe.
might try to. We'll wait 30 or 45 seconds to see if he shows back up. It does not appear that Mr. Bichelle is going to join us, so we will take this case under advisement and we will rule based on the oral argument we've had so far in the briefs. Court staff, if you would close out this oral argument and set us up for the next one, I appreciate it. Thank you, Mr. Carson.
Thank you,
Your
Your Honor.
argument.
Thank you.
Gallery view. Why is it small? Meeting is now streaming. What?
Yeah, I think that's on their side.
Hello, Mr. Bichelle.
Yeah,
The panel decided to just
yeah, let me go. Okay.
consider the case on the briefs and the
Oh.
argument so far. Is there
I-
anything,
No, I apologize. Sorry, I don't know why that happened. It just froze up on me.
sometimes it's the weather. Anything you want me to pass along
Just
to?
my apologies and thank you for consideration.
Well, thank you for calling in and we'll see you next time.
Thank you. Bye-bye.
Why is it small?
Well, because you're connected from their side right now.
Okay. Morning, Bill.
Morning, Taylor. How are you?
I'm good. How you doing?
I'm doing great. Second one of these in 2 days.
Yeah, I saw you were on the calendar yesterday.
Oh.
Good morning, Your Honor.
Morning, Judge.
Hello,
Thank you.
panel. It's Christina, just letting you know that Mr. Bichelle did call in and extends his apologies. The internet dropped on his end.
Okay, well, thank you for letting us know about that. Our next case is 20-1892, Sophia Sandiford versus Acres Custom Homes Incorporated and Amerisure Insurance. Mr. Davidson, are you ready to proceed?
I am, Your Honor.
You may proceed.
All right, if it pleases the court, I do represent the claimant, and I would like to reserve 6 minutes, I guess, since I have 20 for rebuttal.
Okay.
I believe this case really should start with the dollars. We all know it's a death of a 16-year-old boy on his first day of work. But the dollars inside the family are what drive, in my mind, the result of it should be a finding of dependency. There are $1,590 in total family income. That was found by the judge, and that is comprised of really three things: food stamps, child support of $78, and the SSI payment that is probably the crux of the issue today. That is $849 of unallocated money that they can spend however they wish. Against that, we have the expenses. The rent is $650, water $100, electric $880. So we have $830 in expenses that are basically for the shelter, so to speak, of the child, with the food being taken care of by the food stamps. So that's the total family expenses, other than a car that gets repossessed after the death. And after Dartavius's death, the SSI payments that he was receiving ended. And once they ended, it was just, even according to the judge, devastating financially on the family. They lost their home. They had to relocate, be in with family. And really, it was a devastating impact on the loss of that income stream. And the case law shows us that that negative impact is a powerful indicator of dependency. And that's the wise decision, I believe, that's cited in the materials. So we know for a fact that that loss led to their dislocation, or their having to find and move in with family. So dependency, at least in my mind, is pretty straightforward. Now, there are two cases that are the crux of this analysis. That would be the Paget case and the McDonald case. Paget's pretty simple and straightforward. It involved a man, a adult child that was living independently from the mother that was killed. The mother was there for 2 or 3 weeks out of the year with no evidence of contributions per se. And they found that was not a dependency situation, not surprisingly, because they indicated there had to be proof that there were substantial contributions made. Well, there was none of that in Paget. So, or in Paget. And then that's in the 40s. 25 years later or so, along comes McDonald. And McDonald does involve a minor child. But it was a minor child that really it was unlike this case in that there was no other income attributed to that minor child. So when that minor child was killed, that went up to the Supreme Court, and that was a very different decision, because in that particular case, it turns on to a great degree that there was no proof in the case. It was really more of a CSE case than anything. But the sequence in that case is really important, I think, to follow, because they're going through the facts, and then they make the statement, the sentence that's probably got us here today. Okay, they make a statement essentially saying we presuppose that Paget meant that the decedent had to be able to support himself and contribute to the support of another. It's not really what the judge below said, but that's what they said in McDonald. But that's not what Paget said, and they cited Paget to say it. Okay, and then they made some other statements, but most importantly, they moved on and eventually made a test, the McDonald test. Said nothing about that sentence. Okay, that sentence is not in the test because it wasn't mentioned in McDonald or wasn't mentioned in Paget, so it's not there. And that was my first issue. Was I think that sentence is dicta. You know, I don't see how It didn't drive the decision.
Counselor, how about instead of dwelling on the meaning of dependency, and I imagine there's not much doubt that in some way or another, your client is dependent. I think the question on the statute is dependent upon whom? And so how is your client, or how was your client dependent upon her son
All right.
before his death,
I understand.
as opposed to dependent upon, say, the federal government?
Well, I would say that the reason for that is, or the way I look at that is, but for her son being there would be no SSI money coming in.
Right, but what is the purpose of the SSI money?
The purpose of the SSI money is the current maintenance of really the child, but also secondarily the family unit. If you look at, and I cited this in the materials, current maintenance includes both food and shelter. Now, let's be logical about this. If you're in this income situation here, okay, what are they going to do? They have to rent a house in order to provide shelter for the child. You can't say that, well, they should only be able to pay for 20% because there's 5 people in the home. Only 20% of that SSI money should go to supporting just him. They'd be homeless. They would not be able to secure a home to live in for any of them if they didn't use that money towards the support of all of them.
Sure, but was the SSI money going to the son because of his disability?
It was going to him because of some sort of learning disability, as I understand it.
So wouldn't it be fair to say that the SSI money was intended to offset expenses and other, items, costs associated with that child and his disability?
I don't think, no, not on the disability. I think that the issue is because he was disabled,
He couldn't work.
that money was paid to take care of his current maintenance.
Okay, but it was still to offset costs, right? The portion of costs that his family was incurring. If it were otherwise, then she'd still be getting there'd still be SSI for him, even though he died.
Well, yeah, I get what you're saying, and I guess that's correct. I mean,
so then how does that not fit into what McDonald did say? There's several quotes talking about just offsetting room and board for the child is not the same as supporting the parent.
Well, I think what McDonald said, if I understand what you're talking about, they were talking about it has to be proof that the person's doing more than just pulling their own weight.
Right.
And
how is it that the SSI, let's assume, and I'm not, it's a separate question whether as the appellee is raised about earning power versus this, some sort of welfare payment from the government. But let's just take that theory for a moment. Let's say benefit payments from the government counted in some way. How is it that the SSI for this child was anything more than just counting for, to use it informally, pulling his weight at the time?
That's what the case says. And
sure, no, I understand.
They took that from Larson, and there I think the issue is a math problem. That's why I started with it. I think if you do the math, you come up with his share of the family expenses was $300. Okay, well below what he was actually getting in SSI. So if you do the math, like all the family pot doctrines have done for years, if you do the math, you see that he was not only paying for his share, he was paying for the share of another and part of the share of another still. So he was doing well more than just carrying his own weight. By those payments, he was the thing that was supporting the family. Okay.
Well, let's back. So terminology, I think, is going to end up being important. So he wasn't doing anything to support the family, right?
His efforts were not. I would agree with that. I mean, his existence was because they wouldn't get the benefits without him.
Sure.
But that was not money that was earned by his efforts.
Right. It was the federal government that was supporting the mother and the family.
Because he was there, because of his disability, that income stream was in the household. Yes.
Sure.
From the federal government.
And do you disagree with the appellee's characterization of federal law that any excess money beyond the child's own expenses are supposed to be held in trust for him?
Absolutely. I think that is really contradictory to the entirety of that system. The reality of this is for the current maintenance of the child. Like I said before, if his position was correct and any excess needs to put in trust, that family would have been on the streets. They would have been homeless. None of them would have had anywhere to live. That would be absolutely contradictory to the intent of that statute. That's not what it's for.
But if that's true, that's also contradictory to your argument. So if the benefit he received, having a roof over his head, would have exceeded $300, would it not?
The roof over his head did exceed $300. The rent was $650.
But and you're suggesting though, if the money had been put in trust, they would have been out in the street. So if we're talking about his SSI benefits, it really would have been more than $300 in terms of the benefit he was receiving and his portion of the expense, because the roof would go away under your argument.
I'm not certain I follow. I'm saying that his share was $300. If they were saying only $300 can be spent for him, and the other $400 and some change we put in trust, if that was the case, what I'm saying is they can't rent a $650 home. They wouldn't have a place to live, and that $300 would basically be wasted. If I'm not certain how that's inconsistent with what I was saying.
I understand.
Okay. If I'm missing something, please tell me. I don't like these video things, so if I'm not following you, let me know. All right. So the other thing I really want to talk about is and it kind of goes into. I'm sorry.
Let me ask you. But let's again focusing on the statute. Or do you agree that the focus here is 44016 1B and the meaning of the phrase on account of dependency upon the deceased, and maybe secondarily dropping down to B4, talking about the payment to the parents, such compensation be paid during the continuance of dependency? Are those the phrases that we're really focused on here?
That is what I would think the focus should be upon.
Okay.
I don't know. That was
go ahead.
I don't know that's what the judge focused on, but I think that should be the focus. Yes.
Okay. So dependency upon the deceased, which is the child here. It talks about being paid compensation to be paid during the continuance of dependency. What with the child passed now, how do you define the continuance of dependency? Like, that's why I asked before, dependency upon whom? So as long as the mother continues to need federal payments from the government, she's considered dependent, and so the employer is on the hook for that?
If I understand what you're saying, yes. They were clearly dependent upon that income stream, whether we want a federal government, whatever. They were dependent upon it. Okay. And because my reasoning is they're dependent upon it, they don't get it but for him. So they're dependent upon him by reason of that. The continuation of that dependency, nobody's guaranteed tomorrow. Okay. He knew he was going to get it while he was living. We know that he would have gotten it certainly until he was, 19, maybe longer. You never know but that's the issue. I think you have to look at it now. Okay. Was the dependency then? Yes. Was the dependency expected to last into the future? Yes. Do you then parse that and say, well, how long into the future? Should we do it for 2 years? I don't believe that's what the case law really suggests, and that's the intent of, not the intent of it, because how can we really tell the future?
Well, why wouldn't it? Yeah, go ahead. Sorry.
We know what the situation was on the date of his death. We know what that was, and we know realistically what would have happened in the years following. After that, who knows? Because we don't know really, we can't tell the future yet.
Judge Roberts, I'll wait for rebuttal. I know that we're into I think it was 6 minutes.
Oh, I'm sorry. I'll
But I'll stop
yield.
asking.
All right. Thank you, Judge Tannenbaum. Mr. Rogner, are you ready for your argument?
I am, Judge.
You may proceed then.
Thank you very much. Good morning. May it please the court. My name is Bill Rogner. I represent Acres Custom Homes in Amerishore. Your Honors, Mr. Davidson and I have worked intimately with this case since day one, and we agree on one thing. Dartavius's death was a tragedy. And this case is not about the tragic death. It's about the dependency question. And Judge Tannenbaum, you referenced the statute where it specifically says that compensation is only paid during the continuance of dependency. And that means that one can be dependent on the date of the death, and I don't accept that she was for workers' compensation purposes, but even if she was no longer dependent by the time of the litigation of this case. She testified at page 76 of the record that she had a job. She was making $336 a week. She had not worked for the 8 years prior to Dartavius's passing, but she got a job after he passed and was making double what he was receiving in SSI at the time of this deposition. So my position is, even if you accept Mr. Davidson's argument that she was dependent, she was no longer dependent. The continuance of dependency had ceased. Now let's go to the real crux of the question, because this case is about the SSI, okay? Dartavius never, not once, contributed 1 penny to the family, ever, including the SSI. Here's the way it works. The mother is the representative payee. The federal government does not give a disabled minor child money. They give the parent the money. She testified that she had a debit card. It was auto deposited on her debit card. She had another one for another child that was on SSI for a learning disability. She had a separate card for that young lady. She received the money directly. Dartavius did not contribute the money to his mother for her support. If you look at McDonald, they cite McDonald on 24 pages of their brief. McDonald, in 4 of the 6 elements of that test, talks about substantial contributions made by the decedent to the parent. He never contributed anything. To contribute means to give. He never possessed those funds. Only the mother possessed those funds. And you also look at the 4th part of that McDonald test, and it says that it must be shown that these contributions, assuming this was a contribution, would exist into the future. And Dartavius's SSI benefits by law would have ceased in December of this year. Mr. Davidson said in his presentation that who knows, they may have continued longer. No, they wouldn't, because the SSI benefit payable to a disabled minor child ceases upon the child's 19th birthday. So she would have lost his benefits in December of this year. Therefore, the disability or the dependency or the income would not have continued. You also point out, Judge Tannenbaum, that the contribution was not made by the son to the mother. The contribution was made by the federal government to the mother. And if you look at all these cases that are cited in Mr. Davidson's brief primarily, but McDonald and Paget and all the other cases he cites, what the courts do when they're analyzing this parental dependency thing is they say, okay, let's look at the decedent's history. What did the decedent do before the date of the death? Because McDonald was a minor child killed on the first date of accident, first day of employment, just like Mr. Outsey was killed on the first day of employment. The Cross case cited in the briefs, 11th day of employment. What do they do? So they say, okay, what did this decedent do in the past? Did the decedent have odd jobs? Did the decedent have a regular job? And then what did the decedent contribute to the budget of the parent? It doesn't have to be cash. You don't have to pay the mother cash, but typically they're paying their rent. They're bringing them groceries every week. But it's all focused on the earnings of the decedent and how those earnings were contributed to the parent. And there's a reason for that. I learned my very first week of being a workers' comp lawyer, which was 30 long years ago, that workers' comp compensates only two things. There are two buckets in a comp case: medical, and in a death case, funeral expenses, and compensation for lost wages. You look at the Malarkey case, Florida Supreme Court case, addressing the death benefit statute. It's talking about the dependency requirement, explaining why it matters. And it says, relief under workers' compensation is directly related to loss of earning power, either to the employee or to those financially supported by him. So it's a workers' compensation case. We compensate people for lost earnings. Unfortunately.
So Mr. Rugner, I think the argument though is this stream of income, wherever it comes from the federal government, is earnings that would not have existed but for the decedent's presence in the household.
Sure. Well, I don't accept the term you used, earnings, because it's definitely not his earnings. He didn't earn it. She didn't earn it. Nobody earned it. It's a social welfare benefit paid to a disabled minor child. And look, I concede that the mother was using that money to support herself and the family. Okay. Now, my counter to that is that it's not appropriate to do that. I cite the regulations, the SSI regulations and the SSI statute, including the criminal statute, that says if you convert that money to the use of another, that you violate the law. And I'm not impugning her character. I'm not impugning her motives, but she testified that she took that money at various times, paid the cable bill, page 68 of the record, paid her car payment, page 69 of the record, bought gas, 69 of the record, gave money to the other 4 kids when they needed it, page 83 of the record. So each time she did that, she was taking money that was intended for Dartavius, and she was using it for other purposes. Now, I don't dispute, I'm not, like I said, I'm not impugning her character. She's trying to support her family.
Yeah, but that's just part and parcel. You know, if you have a family and a bunch of kids, you have money that comes in and you spend all that money on your kids. That's just the way it works.
I don't disagree with that at all. I totally understand that. But Your Honor, look at the facts of the case. She testified that she did not work for the 8 years before this incident occurred. Okay. What did she live on for those 8 years? She testified that she had 2 SSI checks, one for Dartavius, one for his older sister. She also received some child support, and she received assistance from her mother and a sister. That's what she lived on for 8 years. Dartavius is killed in July. She testifies that she gets a job in August. And she had lost both SSI checks. The older sister aged out of the system. Then she loses the second SSI check when Dartavius passes, and she immediately goes back to work. And at the time of the deposition, she's making twice what she was making from Dartavius's SSI check. I don't accept that she was dependent on him. She was simply using his federal benefit to support herself and her family. And I'm not saying that's evil. I'm just saying it doesn't demonstrate dependency for purposes of the Workers' Compensation Act. You cannot find one appellate case, and I've also looked, we can search easily now, trial cases, JCC cases that go back to a certain, I think it's 1994 or something we get back to now. I cannot find a single case where any judge has ever said, okay, we have a death, we're considering dependency of a sibling or a parent, and we're going to consider the social welfare benefit or the food stamps or something that they were receiving. All they look at is what was the person earning, were they supporting themselves, and then in addition to that, supporting the parent in some way. And again, it doesn't have to be cash, but it has to be financially supportive.
Counsel, to what extent do you think inherent in 44016 is an anticipation that there's a choice made? So the wage earner, let's just say a classic wage earner, consciously is supporting a parent or a child, makes this that I'm working and I'm going to contribute a certain amount to help a parent or a child or something like that. Is there some sort of choice component to it, and is that a distinction that you're making between benefit payments from the government here and your typical wage? What you think you said, or the courts have said, earning power?
Yes, that's exactly the way I looked at the case from day one. When the client called me about the case, Judge Tannenbaum, I said, okay, this is not a decision that this young man made to support his mother. This is not something that he had any say in. He didn't make any choice. He had no authority to do so. He's a disabled minor child. And there's certainly no evidence in the record. The mother did not testify, for example, well, Dartavius always wanted me to have this money. Dartavius wanted me to spend it on me. Dartavius wanted me to spend it on the other kids. There's no evidence of a conscious decision. And when you look at all the cases that have been decided, that's what they're looking at. They go back and they say, okay, this guy worked odd jobs, but he always brought his mother $20 at the end of the week. Okay. There's a conscious effort of the employee, workers' compensation case, to support the either sibling or parent, which is the classifications of family relationships that focus on this dependency issue. And that's also why, Judge, you point out that language during the continuance of dependency. When a parent is dependent on a child, if you look at, for example, McDonald, the McDonald mother was herself disabled. And it's a need by the parent to be supported. And in this case, the claimant testified that she went out and got a job because she didn't have the SSI checks anymore. So she's not dependent on those SSI checks. It was, for lack of a better term, it was a choice to live on those checks as opposed to going into the workforce and getting a job. And that's not a choice that the injured worker made. It's a choice that the claimant made.
Is that on the continuance of dependency? Is that a fact question? Could a parent be dependent for a period of time, and could the employer carrier at some point assert that, look, you've had plenty of time to find a job and take care of yourself, and you're not doing it, so we're going to terminate?
Well, I don't know about those facts, Judge, but I've handled plenty of cases where a parent was dependent at the time of the death on a child that was supporting them. And then later that parent went out and became employed. And then we take the position that they're no longer dependent because the period of dependency has ceased. And those are the facts of this case. This is not what the order turned on. The judge didn't really address the continuance of disability. The judge sort of, the only criticism I'll give the judge in this case is the order is brief. There are few words in the order. At the same time, the statute only requires a finding of ultimate fact and conclusion of law that allows the judge to reach the conclusion. But I would have preferred a lengthier order that had a little more explanation in it. But I think it's clear that she said, at the time of the death, the deceased was receiving SSI benefits from the Social Security Administration to be used for his support. He had not, prior to the accident resulting in his death, held a job or contributed to the family in any other way. So I think that.
Well,
go ahead, Judge.
What do you make of the fact that continuance of dependency really is only found in the subparagraph dealing with parents?
Because that's the only place we use that continuance of disability. That's the only place that I've ever seen it analyzed. If you look at the case law, we don't talk about the continuance of disability of a minor child. So for example, or the continuance of dependency for a minor child, the dependency of a minor child is defined by age. the child ages out either at 18 or 22 if they're a full-time student. And that's simply defined in a different part of the statute.
Sure, but a spouse gets the benefit for until death.
Correct. But
And it could have been the same though. It could have been for the continuation of dependency, and presuming that maybe the spouse goes out and gets a job.
Right. The legislature could have done that. They did not.
Right.
But we're talking in this case not about a spouse, obviously, and not about a dependent minor child, but about a parent. And that very clear statute requires that there be that it only applies, or the death benefit is only payable during the continuance of disability.
What if the child here had worked for a week or a month before his death? At what point is there a calculation? Okay, well now he's using wage power or wage earning power to support his mom in some way.
Well, there's never been a case that says it has to be X number of days, obviously. McDon, if we look at the cases that have been decided, McDon was a death on the first day of employment ever. The Cross case was had been 11 days, and the court found that was not sufficient to work for 11 days. McDon makes it clear, all these cases make it clear that it's fact specific for the judge to determine whether there was. And if you look at the McDon test says, how do we do it? Well, dependency existed at the time of the death. Okay. That the deceased employee must have actually made substantial contributions towards the support of the claimant, and an expectation of future contributions is not enough. So for example, Mr. Davidson could not have said, well, at some point, Dartavius would have gotten a job and then he would have contributed to the mom. That's not good enough. That such contributions must have been made regularly and with a reasonable expectation that they would continue to be made in the future. These are what we would analyze. And so, I mean, I can imagine a situation where somebody worked for 6 months or 3 months or whatever it was, and all that money, I came and I gave it to my mom and I supported my mom with that money, and that may be enough. But that's clearly not what we have here. The only evidence in the record about what Dartavius did was he took a day job for 1 day, and his mother testified that she believed he was going to take that money, that $125, and buy himself a pair of shoes. And so there's no evidence in this record that even the wages that he earned on his 1 day of employment were intended by Dartavius to support the mother, to support the family, that he was going to use those wages for himself. Again, there's nothing wrong with that, but it doesn't suggest that the mother's dependent on his labor. And I simply do not believe that in the workers' compensation system, it is sufficient to establish dependency merely by saying the federal government pays me as a result of my child's disability, and therefore I'm dependent on my child. I don't follow that logic, and I haven't since I first got the case, and Mr. Davidson and I have disagreed from day one. Now, Your Honors, if you don't have any further questions, we ask that you affirm the decision appealed. Thank you.
Thank you, Mr. Wagner. Mr. Davidson, you're recognized for rebuttal.
Yes, sir. Thank you, Your Honor. I have a couple things I want to just hit real quick. One, on the minor child parent thing, remember there are 2 minor siblings that are also claimants in the case. His siblings also were minors at the time. Now, on the wages, earnings, all this stuff, I mean, I have a number of problems with this, as included in my briefs. One, non-monetary contributions under the case law are included, okay? So if it's non-monetary is included, why are we focused on earnings or wages? The real issue here is money, okay? It is about that income stream, and is that income stream tied to Dartavius? We know that in other cases, AFDC, Social Security is included in the pot. Those cases are cited. So we know this thing about, oh, it's federal government. Well, if it's federal aid, why would AFDC have been included before in the family pot question? It was, okay? It has, that case is cited in the briefs.
Well, counsel, let me focus you though on 440.16. again. You know, let me ask you a basic question. You know, we're talking about your client, the claimant. She's the parent, and we're talking about 25%, right? That's what she's seeking.
I believe that's, yeah,
Well,
that's
where
what
it just take the percentage that's provided in the statute.
right.
What do you consider that to be a percentage of? Wouldn't it be the average weekly wage?
Yeah, well, it's a percentage based upon the average weekly wage, which we already agreed upon. We stipulated well before the trial that the average weekly wage based upon the earnings was $600.
But that's what he would have made at the employer had he survived his first day.
Correct.
Right. So, but why would you stipulate to that if the basis for dependency is this SSI payment?
Well, you can have two sources of income if you're talking about.
Sure, but the statute is designed to supplement to fill in the lost wage because of the death, and it speaks in terms of dependency, presumably the dependency on the decedent as the wage earner.
Well,
so if you're stipulating that the average weekly wage, which is the basis for this percentage for the benefit, is not the SSI, but the money he would have made or what his weekly wage would have been at the job, aren't you conceding that the dependency has to be based on income as opposed to SSI?
No, respectfully, I disagree. I have to agree on an average weekly wage because benefits can only be paid based upon it. So if you have a zero average weekly wage, like we see in some of the undocumented worker cases, okay, you've got a zero undocumented wage. You've won the battle. You've lost the war. You have a right to zero. So we agreed to that really as a convenience more than anything because it's a wonky situation and we wanted to figure out what the average weekly wage was up front.
Well, it's more than just go ahead. You finish.
I want to make one quick point because we talk about the federal government, the genesis of all these funds. What if the genesis was not SSI, was in fact a trust that he was going to be paid for life or an annuity that he got after an injury or something, okay? And they were paying $771 a month. And that was going in same dollars as we have here. And then he was killed. Under what situation? I don't see how you could say that money does not go into the pot. It's the same thing, and I don't understand why SSI should be treated differently. If no other further questions, thank you very much for your time, and we request that the order on appeal be reversed.
All right, counsel, thank you very much for your arguments in this case. Being we have no other cases this morning, we will stand adjourned.
Thank you, Judge.
Y'all be well and safe.
Two.
Turn this off.